Good afternoon, everyone. My name is Panayotis Shalkias, and I'm a Young AFSA co-chair. Together with our colleagues at the Young AFA, we would like to welcome you all to this joint webinar on the enforcement of arbitral awards in four selected jurisdictions: South Africa, Zambia, Zimbabwe, and the United Arab Emirates. We are happy to see that this webinar has garnered significant attention and happy to see that many people are joining today's webinar. Please note that the webinar is being recorded as you can see on the Zoom application, and the recording of this webinar will be available on AFSA's website in a few days. With that said, I would like to thank Young AFA and its representatives. So Charles Martin Moon, who will be also my co-moderator, and Muleba Joseph Chitupila for their pleasant collaboration and joint organization of today's webinar. I would also like to thank our stellar speakers for being with us today. We are lucky that they're here to share their invaluable knowledge and experience in the practice of domestic and international arbitration. Charles will be introducing them to you in a few minutes. And last but not least, I would like to thank our mother organization, AFSA, for their support and for hosting today's webinar. Finally, before we start the webinar, we wanted to give you a brief overview of Young AFSA and Young AFA for those of you who are interested in our activities. Young AFSA was created in 2023 and is dedicated to cultivating a vibrant community of young professionals and students from Southern Africa and beyond. Our mission is to promote knowledge sharing, skills building, and networking within the field of arbitration. Young AFSA operates under the mandate of AFSA, the Arbitration Foundation of Southern Africa, and we currently have over 530 members. Joining Young AFSA is free, and it can be done very easily by filling out the registration form that is available on AFSA's website. The only requirement is that applicants must be below 40 years of age and have a keen interest in arbitration. Recent examples of our activities include a series of 3 webinars on mastering mediation, which are available on AFSA's website, the launch of the inaugural cycle of Young AFSA's mentoring program, and a joint Young ICA, Young AFSA workshop on mastering written and oral advocacy in international arbitration, the recording of which is also available on AFSA's website. If you're interested in Young AFSA and its activities, please visit our website and feel free to follow us on social media. And if any of you has any suggestions or proposals for a future Young AFSA activity, please feel free to reach out to us. Going back to today's webinar, I wanted to share a few words about the format, the structure of the webinar. So together with Charles, we will be moderating the contributions of our speakers. To this end, we will be asking them certain questions, and they will be answering them in a random manner among the 4 of them. We will make sure that the discussions remain as interactive as possible. And once we are done with our questions, then we will open the floor, if I may say so, and ask our audience to pose any additional questions that they may have to our speakers. So if you're interested and want to participate in the Q&A session, please feel free to use the chat function of Zoom. I will now hand over to Charles, the Young AFA representative and co-moderator, who would also like to share a few words about Young AFA and who will also introduce the speakers. Thank you.
Thank you very much, Panos, for the warm introduction to this webinar, as well as the Young AFSA. Good afternoon, good evening, good morning, depending on where we are. Basically, before we delve into our main agenda today, as Panos has said, I would also like to introduce the Young AFA. So Young AFA is a vibrant group of under 40 arbitration practitioners from various jurisdictions within and beyond the continent. As a platform within the African Arbitration Association, we are dedicated to nurturing the next generation of arbitration professionals. Our mission is to promote excellency, innovation, and inclusivity in international arbitration and alternative dispute resolution by providing young practitioners and students with opportunities to grow, network, and collaborate. Through initiatives like the present webinar, we connect emerging talent with established experts, equipping young professionals to actively contribute to the growth of the practice of arbitration in Africa and globally. Members of Young AFA benefit from a supportive community, mentorship opportunities, knowledge sharing events, and access to the latest developments in the field. We also provide a platform for showcasing skills and engaging in discussions that shape the future of dispute resolution. And as Panos also said, if you want to know more about us or join this exciting community, please visit the African Arbitration Association's website and our LinkedIn pages, both for the mother body as well as for the Young AFA. We are always eager to welcome new perspectives and expand our network. So that's all about the Young AFA. So in terms of today's webinar, we aim to provide legal practitioners and professionals and students with a comprehensive understanding of the complexities involved in enforcing arbitral awards in the jurisdictions that Panos mentioned earlier on. So in this webinar, we are honored to have 4 distinguished speakers who will share their expertise. Firstly, we have Annie Kawandami Kamwendo. She's a legal advisor with over a decade experience across various sectors, including mining, agriculture, government, and nonprofit. She holds a Master of Laws from the University of Zambia and is an associate member of the Chartered Institute of Arbitrators. So for her, she will provide insights into the enforcement of arbitral awards in Zambia. And then secondly, we have Rana Musa. Rana is a senior associate at Reed Smith with extensive experience in complex high-value cases across the Middle East and North Africa. She specializes in cross-border commercial construction and energy disputes. And she also serves as the vice chair of Young AFA. She's my vice chair. She will be discussing about enforcement procedures in the United Arab Emirates. And then thirdly, we have Gerard Rudolph, who is the managing partner of A&O Chairman, South Africa. He represents clients in a wide range of contentious and risk management issues, including civil litigation and arbitration proceedings. He has over 25 years of experience. He's recognized as a leading dispute resolution lawyer in South Africa, and he will cover the enforcement landscape in South Africa. And lastly, but not least, we have Tawanda Jwarara. He's an advocate of the Superior Courts of Zimbabwe with 18 years experience, and he specializes in commercial litigation and arbitration. He has extensive experience in public and private sector disputes and is regularly briefed in matters relating to public and constitutional law. Tawanda will provide an analysis of enforcement processes in Zimbabwe. In terms of the structure of the session, I think My colleague Panos has already alluded to that. Maybe just to emphasize that in the event, maybe as presentations are ongoing, in case you have questions, you can use the chat function and put your questions there. They'll be addressed during the Q&A session. Without further ado, let's begin with our first speaker, who will be taking us through the landscape in Zimbabwe, and this is Annie. Annie, the floor is yours to kickstart the session.
So Charles, yeah, sorry, just allow me to ask the question first, and then I think, yeah, Annie can be the first speaker to answer it. And of course, if any of the other speakers wants to jump in, feel free to do so. So to start us off, Annie, can you please tell us about the legal framework related to the enforcement of arbitral awards in your jurisdiction in Zambia, and whether that legal framework makes a distinction between domestic and foreign arbitral awards?
Thank you so much. So I have a few speaking notes to guide me, and I'll use those if that's okay. Right. So to answer your question, the legal framework that governs the enforcement of arbitral awards in Zambia and applies to both foreign and domestic awards is the Arbitration Act number 19 of 2000. And to be clear, the Act doesn't differentiate between the enforcement of foreign awards and those that are rendered locally. And this is mainly because Zambia is a party to the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. So this gives us that platform to be able to handle foreign awards when they are being enforced here in Zambia. Thank you.
Rana, do you want to go second?
Thank you very much, Panos. But again, just as an FYI, everyone, I'm really sorry for my voice. I have the flu, so if you need me to just go higher, scream, please let me know. With regards to the legal framework in the UAE and whether there is any distinction between domestic and foreign awards, I wouldn't say that there is a distinction per se between domestic and foreign awards, but the distinction is whether the award itself is subject to the arbitration law or not. When is an award subject to the UAE arbitration law? Just as a background as well for UAE arbitration law, it's number 6 of 2018. So when it was issued back about 6 years ago, it really changed the to be honest, the scene here, the arbitration scene in the UAE, and it really progressed how arbitration is progressed, how arbitration is enforced, awards are enforced here in the UAE, and it streamlined the process. So the UAE arbitration law is applicable when we have an arbitration that's either subject to the UAE arbitration law or seated in the UAE, so with the UAE seat. That's when we apply it. So, and then any other awards that are not subject to the UAE arbitration law are then going to fall within or under the civil procedure law of the UAE. But again, just to give you a brief perhaps background or explanation of those two. So the process of execution or enforcement are really not that different between the UAE arbitration law or the civil procedure law. It's mainly the timelines where we see really huge differences, and also the court within which we will bring the enforcement or the recognition application itself. And I believe that we will delve into this later on into more details.
Indeed. Thanks a lot, Rana. Gerhard, would you like to share your input on South Africa?
Certainly happy to, Panos. So South Africa has the curious distinction of applying different legislation to the recognition and enforcement of domestic arbitration awards as opposed to international domestic awards still being subject to our 1965 Arbitration Act, which mirrors the historic English acts of the time, and then the 2017 International Arbitration Act, which by and large mirrors and adopts almost in its totality the UNCITRAL model law per the New York Convention. In practical terms, there's no real distinction. The requirements for purposes of recognition and enforcement really just follow the UNCITRAL model law in terms of finality, establishing jurisdiction, and avoidance of the typical grounds for challenge on public policy, etc. And enforcement in all instances would have to be by way of court applications. So motion court format in the High Court would typically be the process to follow in enforcement.
All right, that takes us now to Tawanda. Tawanda, would you like to share your view from the Zimbabwe perspective?
Oh, certainly. Thank you very much. In Zimbabwe, we enforce arbitral awards in terms of the Arbitration Act. That Arbitration Act actually replaced a previous act also called the Arbitration Act. So we're very, very ingenious about naming our acts. But the fundamental difference of the new act is that arbitral awards are enforced as arbitral awards. Previously, arbitral awards were converted into court orders. So what you would do in the previous structure or superstructure of legislation, you would come with your arbitral award and have it converted into a court order, meaning that now it is under the hand of a judicial officer in Zimbabwe. But the new act, which basically seeks to answer and inculcate the international norms, is fundamentally different in that an arbitral award is enforced as is. There's no distinction between international awards and local awards. Both of them are looked at the same way with equal weight, but with a small caveat. If you have an arbitral award in Greek or in any other language, certainly you would have to have it translated in terms of Section 17 of our Civil Evidence Act. Once it's translated and we can all understand it, it will definitely be placed before a judge. Like Gerard's analysis, it's similar to South Africa. You come with the arbitral award and it is subjected to our civil procedure, which basically does a little check on every little aspect of the award. Is it in English? Can we understand it? Can we enforce it? And that is basically how arbitral awards are enforced in Zimbabwe.
Thank you, Tawanda. I think your point on the translation requirement segs, it's a good segue to our second question, which is what is the process of enforcing an award in your respective jurisdictions, and as part of that question, what are the documents that you would need to submit if you are applying for enforcement before your local courts, and are there any procedural steps that one should be aware of before initiating this enforcement process? So perhaps for this question, we can start off with Gerhard.
Sure, happy to. So South Africa again follows the conventional process in terms of the New York Convention. One would firstly have to satisfy a court insofar as its jurisdiction is concerned, and in South Africa, court will not just automatically adopt jurisdiction, particularly if the party against whom the order is sought to be enforced is not ordinarily a resident or domiciled within the jurisdiction. You may then have to demonstrate that there are assets or that are potentially capable of attachment to give effect to the recognition order. Alternatively, that there's some other cause of action that arose either in relation to the submission to arbitration that would enable a South African court to assume jurisdiction for purposes of recognition and enforcement. You'd have to demonstrate to the court that there was a valid agreement to arbitrate in place, satisfy the court that at least at face level that there was no irregularity in relation to process, that there was in place a final and binding arbitration award with due notice to the counterparty, and that at least on the face of it, there's no potential issue insofar as the subject matter of the arbitration award is concerned, or the award itself that would render it contrary to public policy. But satisfying that, and then otherwise, you know, again, at the risk almost of stating the obvious, if the award is not in English, then one would have to have a duly authenticated original of the award and a sworn translation that would have to accompany that for purposes of enabling the court to recognize and enforce.
Is it also a requirement to produce a copy of the arbitration agreement?
Yes, you would be required to produce the arbitration agreement in order to satisfy the court that the award was granted by a tribunal that was duly constituted.
Great, thank you very much. Annie, would you like to go second?
Yes, please, sorry, I was on mute. Okay, so for Zambia, let me just say that the first step with enforcement is for the winning party to communicate with the other side, obviously to try and do this without forceful means, to say we've won the award, and are you going to, you know, satisfy the steps that have been provided, and only if the other party is not compliant or willing to talk about it is when you proceed to the enforcement stage. And in terms of this, Zambia has a very specific process which aligns with international practice, and it's found in the Arbitration Act, which we already spoke about, which is the Arbitration Act number 19 of 2000. And before this process can be invoked, we first have to satisfy a couple of things, and that is that the particular award, it has that finality aspect, in that it's final and binding in the jurisdiction where it was made. So if there are ongoing proceedings contesting that particular award, then it can be enforced in Zambia. And also there must be a valid arbitration agreement from which that complies with Zambian law in order for the particular award to be enforced. Finally, public policy considerations. The enforcement of the award must not contravene Zambian public policy. So once we've established these international standards, then the following documents must be prepared. The application is made via ex parte to the High Court of Zambia, and the winning party must place before the court a duly authenticated original of the award, or duly certified copy thereof, the original arbitration agreement or duly certified copy thereof. And if the award is not an official language, same as Zimbabwe, it has to be translated. And if there's interest which is being sought on the award, the same has to be specifically stated, as well as the full name, title, trade or business, entity or personal liable for execution. So this is what you produce before the court for that enforcement process to be carried through. Thank you.
Thank you very much, Annie. Before I go to our third speaker, there's a quick question that was posed by a member of the audience, and I think the answer should be, let's say, quick. So let's get to it right now. So it's a question for Gerhard. The question is if there's any judgment that sets out the requirements that an application for enforcement has to meet. Because the person is saying that the Arbitration Act doesn't seem to set out those requirements. So is there a judgment spelling out the requirements that an application for enforcement has to meet?
A particular judgment, I can't point you to a particular judgment off the bat, but you'd have to meet the basic requirements set out insofar as being able to satisfy the court on the sort of core jurisdictional elements of enforcement of an award, which means you need to be able to allege and prove that, one, there was a valid submission to arbitration, two, the court has suitable jurisdiction for purposes of hearing and enforcing the award, and then thirdly and finally that there is indeed, pursuant to the submission to arbitration, a valid and binding and final arbitration award that it can give effect to. So those are fairly trite procedural requirements. I'm happy to follow up in terms of providing more specific reference on that.
All right, thank you very much. Rana, would you like to go third and answer the question relating to the enforcement process in the UAE? I understand that it's obviously a very specific jurisdiction, in the sense that you have different emirates, like different regions, let's say, which I'm guessing they're applying different rules.
So yeah, very happy to go next. So the question here, or the test, is not really particularly with regards to different emirates, because when we're talking about enforcement in general, you will either be applying the UAE arbitration law or the UAE civil procedure law, and that's subject to, as I mentioned earlier, if you recall, whether the award itself is subject to the UAE arbitration law, whether it's seated in the UAE, then it will be subject to the UAE arbitration law. So if the answer is yes, so the first test is, which law are we going to apply? Are we going to apply the arbitration law itself, or are we going to treat it as a foreign award, i.e. apply the civil procedure law? If it's the arbitration law, then the requirements are really quite, the documentary requirements are really few. So you will have to obviously provide a copy of the agreement itself and attested copy of the award, definitely. But on the other side, if we're talking, for example, about an award, a foreign award that is not subject to the arbitration law, the threshold is a little bit higher, in the sense that you will, in addition to the obviously the attested award and the agreement, the arbitration agreement itself, you will also have to provide documents that prove that not only the parties were duly served, but were actually duly represented during the arbitration proceedings, which could be a little bit surprising for some of my colleagues who come from different jurisdictions. Which means that if a party decides, you know what, I'm going to be served, I know about the arbitration, but I am not going to be represented, then this unfortunately might just jeopardize the whole case for the other side. So yeah, this is a requirement from a foreign award perspective. As my colleagues have said, obviously we need to provide translation. So for example, if the award is issued in English, in any other language, in French, for example, the UAE courts, the UAE onshore courts, I must say, the UAE onshore courts are Arabic language courts. So all the documents that are filed must be submitted in Arabic. And not, for example, with our technology nowadays, AI translation or ChatGPT. No, it has to be actually attested by a certified translator, stamped by a certified translator. And if you get it translated elsewhere, i.e., for example, let's say in France, you will have to then get it actually stamped by the Ministry of Justice here, confirming that the stamp is correct. Basically, it's not a forged document. And in addition to that, because the UAE, whether it's an arbitration law award or you are going to be following the civil procedure law, in addition to the translation to Arabic, you will also have to submit a power of attorney, because the UAE is civil law jurisdiction. Power of attorneys are basically vital documents. So the award winner, the party who is seeking to enforce the award, will have to submit, their counsel will have to submit a document evidencing that they have been duly authorized by the individual or entity that they claim to be representing. Okay, and in addition to that, a very interesting as well, this is, I believe, a war story, which maybe would really be funny to some of you. So in addition to all the documents that I've mentioned earlier, for the civil procedure law, you will also need to evidence that the award is final and conclusive, which I understand that this is an inherent understanding of, yes, awards are final and conclusive. But unfortunately, although the UAE, I have to say, is very arbitration-friendly jurisdiction, it's becoming more and more of arbitration-friendly, and the judges and the courts are getting more familiar with the arbitration enforcement process. But I have to say, about 2 years ago or 3 years ago, we were asked by a judge, me personally, I was asked by a judge to submit a document evidencing that the arbitration award was not forged or signed by friends, basically 3 friends, 3 random people who are just sitting signing awards. And unfortunately, it was not an institutionalized arbitration. So it was actually an LMAA arbitration, London Maritime Arbitration Association, I believe, Arbitrators Association. So to comply with this requirement, i.e. that the award is final and conclusive, what we did is that at the time we submitted 2 documents, one document issued by the English courts confirming that, yes, this award actually is an authentic document, and another document as well by the LMAA itself, which was really a surprise that they really cooperated to issuing such a document. They don't have to, because only they basically just issue laws. They don't administer arbitrations. So they did issue a document confirming that, yes, this award is actually not forged. This award is an authentic document. This award is a final award. So again, although going back to just recapping, although the UAE can be a very arbitration-friendly jurisdiction, you have to just get your documents in line, understand the culture of the country itself, understand the legal culture of the country and what's required, which laws you have to follow. Do you have to follow the arbitration law, or do you have to follow the civil procedure law?
Thank you very much, Rana. I think this was a very good example of how proactive you have to be and have to check all that you meet all of the requirements. But even when you do that, you may still have surprises, and surprises that can cost time and money for the client who has won the arbitration. So thank you very much for sharing this with us. Tawanda, yes, so I think you are the last speaker on this second question about the enforcement process in your jurisdiction in Zimbabwe. Is there anything apart from the translation requirements? Is there anything else that you need to submit with your application, your request for enforcement?
Well, I come from a jurisdiction that loves arbitration because it takes the work away from judges. We're very lazy. Once you give us the papers, we will definitely enforce the arbitral award. And I say that in jest, but in actual fact, it's part of our law. There is a very famous judgment here. I will not give you the name, but I'll just read what they say. They say that I now pause, this is a judge, a Supreme Court judge, which basically explains to everybody how we view arbitral awards. He says, I pause to observe that when presiding over the registration of an arbitral award, the court has very limited jurisdiction. Thus, in terms of the applicable law, an application for registration of an arbitral award is granted upon its mere presentation. Now, what do you present? You present the arbitral award itself, but you also have to present a certificate from the arbitrator telling that you have not fudged the award, you have not made it longer, you have not added zeros, and he basically certifies that this is my arbitral award. You also have to give us the arbitration agreement itself. So if unfortunately you have an arbitration agreement that is separate from the main agreement, you might have a bit of a problem because you will have to present both the agreements, but also it has to be duly certified. Once you have those documents and they are in order, you will get your registration and enforcement. The view that is taken in Zimbabwean courts is that we're not concerned about the actual contents of the arbitral award. All we want to do is to find out, do you have the particular documentation? These are people that decided not to come before a judge. They came before Tawanda. So at the end of the day, they live by the result. And what is basically authenticated is just the documents, to make sure that those documents give us a complete story. So that's the basic position in Zimbabwe as well. It's you have to be very careful about making sure that you produce the correct documents. A number of arbitral awards have not been registered primarily because you have not obtained the certificate from the arbitrator. So you have to be very careful and very pedantic about the documentation. And once that documentation is there and it's complete, making sure silly things like all the pages in the arbitral award are there will definitely save money for your client. Otherwise, we're like in the UAE, we are also very pro arbitration agreements and pro arbitral awards.
Thank you, Tawanda. I think yeah, it's very interesting to know that there's this requirement that the arbitrators themselves, in a way, certify the authenticity of the award. One would imagine that this would be the role of an arbitral institution if you have an administering institution and it's not an ad hoc arbitration. But I guess this is something that you should let the tribunal know upon its constitution. If they're not, the arbitrators are not from Zimbabwe, they would need to know and understand this requirement, right?
Certainly. This is to make sure that whatever document, because most of the arbitral awards that come before our courts are not short, they're quite lengthy. So what usually happens is that, especially if it's coming from another jurisdiction, we just want to make sure that the person who you submitted the dispute to does confirm that this is my document and this is what I agreed to. So it is a requirement that has seen quite a number of arbitral awards get delayed in their enforcement. Indeed, in Zimbabwe, we do not have an institute per se. We believe that parties can, as long as that person is breathing, can eat and can read, they can arbitrate. It is the parties that choose the arbitrator, and all that the courts require is to say, is that person the one that then gave the arbitral award?
Thank you, Tawanda. Before I move to the next question, there is a question from the audience that I think it's very interesting, and I would like to get the views of all of our speakers on this question. So in terms of, again, of the enforcement process, in your jurisdiction, is it possible to have an ex parte proceeding? Yes or no? And of course, if yes, is there any possibility for the court to later on notify the other party and to invite it to participate in the proceedings? I don't know if Gerhard wants to go first.
Happy to go first. So the short answer in SA is no, you cannot do this by way of an ex parte application process. You would have to do it on notice to the counterparty that you seek recognition and enforcement. It may sometimes appear that this sort of process is followed, because what sometimes happens is, especially if it's an international award and the recognition and enforcement is sought on the award with a view to recovering against particular assets that might be in the Republic of South Africa. In order to found and confirm jurisdiction, there may be an ex parte application in anticipation of the recognition and enforcement to first obtain an attachment, which would then be a prelude to the application for recognition and enforcement itself.
Thank you. Tawanda, would you like to go second?
That's a first. I'm usually last in all the registers because of my name. Thank you very much for that. And the short answer is no, you cannot do it ex parte. We don't trust our litigants. The other party should be able to come and object. Our Article 36 does allow other bases upon which to challenge an arbitral award. And just in case those issues exist, all enforcement has to be on notice.
Great, thank you. Annie, what about Zambia?
So for Zambia, the High Court rules actually provide that the application for enforcement is made ex parte. However, once this application is made, the other side will eventually be notified. And if they have a challenge to the award based on the grounds that are provided for in the Act, then you expect that they're going to raise those challenges at that point.
Thanks. And Rana?
The UAE, it's actually the same when it comes to the civil procedure law or the arbitration law. So if we're talking about, again, the distinction that I drew earlier. So the first step is ex parte. Yes, the first step when we're talking about the recognition of the award itself, whether it's subject to arbitration law or not, you file an ex parte application. When we're talking about the arbitration law, you will file it before the appeal court. An ex parte application, a decision should be issued within an X number of days, i.e. 60 calendar days. And then, but the recognition itself will not get you anywhere really. After you get the recognition, the ex parte, again, recognition, what you're expected to do is to start the execution itself by filing a separate application before the execution court. And that application will indeed be served on the party. So the first judgment or the first recognition order will be ex parte, but then once the party hear of it by way of the execution process, they can then challenge it. I mentioned just briefly about the timeline for under the arbitration law, it's 60 calendar days, but if we're talking about under the civil procedure law, again, ex parte, but the timeline is in theory 5 working days, which really doesn't happen. It usually goes longer, about 25 days. But still, it's an ex parte application, ex parte order, decision. But again, once you get a decision in place, you can't really do anything with it. What you'll have to do is to seek separate proceedings or to file separate proceedings to execute the recognition itself, i.e. to execute the award itself. Then the party, of course, will become aware and they will challenge it if they want to. So in short, the answer is yes, it's ex parte.
Thanks, Rana. I think it's obvious to everyone what we see is that the answer to the question is different based on the jurisdiction we're talking about. And I think that's why the topic of enforcement of arbitral awards is generally a challenging one and an interesting one, because again, every jurisdiction, every country will be following different set of rules, different set of requirements. And again, you'll have to navigate through those when you're advising your client in an arbitration. Let's now move to the following question, which is like Rana already touched a bit upon it. It's about the timelines, the deadlines that a practitioner should be aware of in your respective jurisdictions. And in order not to disappoint Tawanda again, I'll ask him to go first and share his views on Zimbabwe.
All right. Just as a tale of the most important thing about arbitration is that once you have the award, you can execute it as the same way as court judgment. So there is no timeline in which you should bring the actual application for enforcement. You should obviously do it within 3 years, which is our Prescription Act, which says that if you have any cause or any right that you want to vindicate, you should do it within 3 years. And an arbitral award is seen as a right or as something that you can approach the courts to seek enforcement. In terms of the other timelines, the only timeline that is there is that if you want to challenge an arbitral award, you have to do it within 3 months. if you want to anticipate. So what usually happens, the practical issue is that a person will approach the court for the enforcement of the arbitral award. And if he approaches the court after the 3 months, the counterparty cannot really come and file an application to have the arbitral award set aside. He will have to make do with your delay. So the short answer is that you can bring an arbitral award and seek its enforcement within 3 years. It will not apply to international awards because we do not assume that you know Zimbabwean law and the 3-year prescriptive period. So you would certainly be able to bring an older award, in an international award, to say, look, I wasn't aware that I should bring it within 3 years, but coming from Cyprus, I have this particular award that needs to be enforced. The only timeline that really limits, that is in the Arbitration Act, is the time in which to challenge the award and have it set aside. Otherwise, you should have comfort for 3 years with your arbitral award.
Thank you. Thank you very much. Annie, would you like to go second?
Yes, sure. So for Zambia, Section 17(3) of the Act actually provides a timeline within which an application for enforcement should be made, and that is that it should be made within 3 months. And let me just add that in Zambia, especially more recently, the courts have interpreted this particular requirement for time very strictly. So I imagine a situation where if an award is brought outside the 3 months and the other party challenges it on that basis, that the courts would side with the other party, just going by the trends that has been shown by the courts, where if an application is made out of time, they just simply dismiss it unless you've got very good reasons. So that's Zambia. There is a time frame, and that's 3 months.
Great, thank you, Annie. Rana, sorry, I know you'll have to repeat what you said before in a way, but yeah, can you walk us through the timelines in the UAE?
So if we're talking about an award that is subject to the arbitration law, it can be really, the enforcement can be, or the recognition application, you can be, there is no really specific timeline when we're talking about statute of limitation, because some of my colleagues have actually discussed that. But when we're talking about statute of limitation, there is nothing that is stipulated under the law that I'm aware of. But if we are talking about how long it takes the court in theory for a recognition decision to be issued, it's 60 calendar days. So from when you file the application within the appeal court, a decision should be issued within 60 calendar days. And then after that, as I mentioned, you have to file separately before the execution court by relying on the recognition decision.
Unati.
And then if we are again still talking about an arbitration award that is subject to the arbitration law itself, there is actually a statute of limitation when we're talking about the set aside of the award itself. So a set aside of the award cannot be brought after more than 30 days from when the award was served on the party that is seeking to set it aside. So this is something that the parties should really be aware of. Again, going to the second relevant law, which is the civil procedure law. In general, the civil procedure law provides that no enforcement proceedings could be filed after 15 years of a judgment being issued. So the civil procedure law applies in this specific instance to both judgments and awards. So it should as well be applied to awards that, for example, if you have an award that was issued in 2000, let's say in 2000, that's 24 years ago. So in theory, it's time barred. It cannot be enforced under the civil procedure law. That's with regards to statute of limitation. But if we're talking about how long it will take for the enforcement or the recognition to take place, as I mentioned earlier, in theory, from when the application is filed with the court a decision should be issued in 5 working days. Again, that's in theory. I have seen multiple examples where a decision is issued in 10 working days, in 15 working days. So it's really subject to the workload of the court, et cetera, to whether you have all the documents presented or the court has asked you for additional documents. So there is really a lot of variables there.
Understood. Thanks, Rana. Gerhard, what is the position in South Africa? Sorry, I think you're on mute. Yeah.
Apologies, you lost me there on the question. Are we talking?
The question is about the timelines governing the enforcement process.
On enforcement, so typically it would be on motion court process in the High Court. Launching proceedings in the ordinary course would probably be a 3 to 6 month process, depending on the degree of challenge. Given that you can't really get into the merits, most of the time there would be very limited challenge, and you would probably be in court within 6 to 9 months, depending on the allocation of the role. If there was no opposition, you could notionally be before a judge within probably about 60 days. If there is an extended challenge, though, and most typically domestically what you would encounter as a substantive challenge to an arbitration award would be an application to review the arbitrator's award based on some element of alleged procedural irregularity. But most commonly, these review challenges are really just attempts at backdoor appeals. This is often quite a successful, frustrating tactic that could drag the recognition and enforcement of a domestic arbitration award out for probably about 18 months.
Okay. All right, thank you. Thank you very much. Let's now move forward to the next question, which is, I think, one of the most challenging aspects of enforcing an arbitral award. And I've seen that, by the way, many members of our audience have asked questions about the question that I'm going to ask to all of you, which is, what are the grounds that a losing party can raise to resist enforcement in your respective jurisdictions? And how do your national courts apply those grounds? So to start us off, I'll ask Annie to go first.
Thank you. So for Zambia, and just to ride on Jihad's sentiments about how this process tends to drag out the enforcement of the award, it's the same in Zambia. Usually an award will be challenged on one of these grounds that I'm about to talk about. And unfortunately, because of the workload in our courts, the process can drag on. He talked about 18 months in South Africa, but in Zambia, it can even drag on for up to more than 2 years. So it is indeed a real challenge for arbitration awards enforcement. So for Zambia, it's Section 19 of the Arbitration Act, and it provides the grounds on which an award can be challenged. Some of this is where the award deals with disputes outside the submission to arbitration, and where the award is not yet binding, has been set aside or suspended by a court of the country it was made, or under the laws it was made, and where the court finds that the subject matter of the arbitration is not arbitrable, as well as if the award conflicts with public policy, as explained by the case of the Zambia Revenue Authority versus Tiger Limited and Zambia Development Agency, in which the Supreme Court of Zambia defined public policy and the thresholds that have to be met to satisfy the section. So what has been happening in Zambia is that often when a party finds that it can't rely on any of the other grounds because they're pretty clear, then it rides on the public policy ground, which leaves a bit of room for ambiguity. So we see a lot of challenges arising from this public policy issue. In addition, we also have what the New York Convention provides, which is that the public policy as well as non-arbitrability of the award and in the inadequate opportunity to present defense. If the other side, as was the issue with the UAE, was not represented, then that becomes something that can be used as a challenge, as well as if the arbitrator was in excess of jurisdiction, and if the award was in manifest disregard of the law. So either of these grounds, the ones provided in our Act or those provided in the New York Convention, can be used to challenge an award in Zambia.
Thank you very much. Thank you, Annie. Gerhard, would you like to go second?
Sure. So I should probably start by saying that there tends to be quite a substantive difference between the approach and challenges to domestic arbitration awards as opposed to international. So domestic awards, as I said before, because the South African courts would inherently have jurisdiction on potential review challenges. By far the most common challenge and attempts at resisting recognition and enforcement, or at the very least delaying recognition and enforcement of arbitral awards, is through judicial review of the awards themselves, and that is very commonly the subject of litigation. The South African courts frown on that and go out of their way in many instances, imposing punitive costs awards on litigants who try these so-called backdoor appeals. But the vast majority of these applications fail, but it does result in quite extensive and in many instances unjustified delay on the recognition and enforcement of many domestic arbitration awards. If one is discussing the South African recognition and enforcement of international arbitration awards, because those are typically not capable of review before a domestic court, unless a party is able to raise as a challenge there that the court should defer on recognition and enforcement because there is a foreign challenge to the procedural regularity or otherwise of the award itself. It is far more likely that those challenges are typically fought first and foremost on the basis of jurisdiction, and those challenges often follow a similar format to the recognition and enforcement of foreign judgments, where parties really try to avoid the jurisdiction of the South African courts accepting jurisdiction over the process on the basis that inherent jurisdiction doesn't exist in the first instance. Then we do sometimes see challenges based on capacity to arbitrate or the issue of public policy, although public policy, and short of something such as, for instance, excessive interest having been provided for, or some other punitive provision being allowed for in an international arbitration award that would not otherwise be contemplated. So, for instance, if it's a US arbitral award and their notions of punitive damages that become apparent in terms of the award itself, that would be something that a South African court would say is contrary to public policy and wouldn't contemplate enforcement. But most of the time, the notions of public policy challenges, even on default awards, are likely to be unsuccessful. More often, as I said, jurisdiction probably first instance, and otherwise possibly some challenge to the submission to arbitration in the first instance, claiming some level of lack of authority or lack of notice on engagement on the process in the event of a default award.
Thanks, Gerhard. In terms of procedural unfairness, I would imagine that the courts would look at the award and see what the procedural history of the arbitration has been.
Yes.
And then based on that, the courts would, of course, defer to the arbitrators. So if there has been a default situation, they would look at what really happened. Was that party notified? Was that party, again, invited to participate in the proceedings? So they will have to go through that part of the arbitration and say,
yes,
well, the tribunal tried its best. There is no ground for
Exactly. So principles of natural justice would apply, and the court would apply a fairly low bar in terms of the expectations that it would place on the arbitrator, as long as reasonable steps had been taken to give a party notice, and the court was satisfied that notice had been given without, and that the arbitrator had given a reasonable opportunity within the broad principles of natural justice to give a hearing to the parties. It's highly unlikely that the court would engage in any further level of depth in investigation. Quite different from in the event of a domestic arbitration, where the court may take a far firmer view as to whether or not the arbitrator demonstrated bias, or there was some other gross procedural irregularity, or failed to apply his mind in the ordinary course. But then it's the principles of review that apply, and the party seeking to review and challenge the award would have to make up that case.
Thank you. Understood. Tawanda, before you answer the more general question about what grounds can the losing party raise to resist enforcement, a participant has asked a question about Zimbabwe, and that question relates to public policy, and the question is how public policy, what is the bar, what is the threshold that a party has to meet to satisfy the court that there has been a public policy violation. So in addressing the more general question, could you also perhaps address the question of public policy in your jurisdiction?
The first thing that we need to establish is how does the law or how do our courts look at this whole thing? The first thing that they do is that they are very clear. And if you don't mind, for the participant, let me quote what our Supreme Court said in 2006. It says that the most important legal consequence of a valid award is that it brings the dispute between the parties to an irrevocable end. The arbitrator's decision is final. There's no appeal to the courts. For better or worse, the parties must live with the award by the arbitrator. So the policy that is now there is that they interpret the basis upon which a person can challenge an arbitral award very restrictively. So the short answer is that public policy is not a valid ground, or is not an all-weather tool that you can use in Zimbabwean courts to challenge an arbitral award. The courts have taken a very reserved approach to say that at the end of the day, the parties chose their adjudicator, and only on very limited grounds can we intervene. Now, the most common issues that are brought as public policy is one, breach of statute. So if there is a particular statutory provision that disallows the type of award that was given, take for instance damages. We have what is called the Damages Apportionment Act, and an award violates damages, that particular act, it will be set aside. There's also the principles of natural justice, which are ordinarily found in your common understanding of common law jurisdictions, things like fairness, the right to be heard, lack of bias, and things like that. But however, we are now guided, and we credit to the South Africans. There is an authority that is now doing the rounds in our jurisdiction, which says that because of the promulgation of the Constitution, it is now easier for us to understand what is public policy. Public policy can be viewed from the perspective of what does the Constitution say. So what does that mean? It effectively means that if there has been some type of violation of a constitutional norm or right, that is the basis upon which you can bring a challenge. However, it is very we do have. I had a very interesting discussion with a judge once who said that arbitration is a godsend, because as judges we do not think. What we will do is that as long as it is properly done, for better or worse, we will enforce. There is also another judgment, recent judgment, but it's not in our superior courts, but it was done in the High Court, which says that an arbitrator has the right to be wrong. It effectively means that you cannot come and seek the impugnation of an arbitral award on the basis of the rightness or wrongness of the arbitral award. So you can have an arbitrator who gets the law wrong or gets the facts wrong. That will still not be a basis upon which the arbitral award can be set aside. There is a very conservative approach there, and you can almost see judges smirking that, oh, you went to an arbitrator and now they got the law wrong. Why are you coming to us to get the situation corrected? So the answer is, at the end of the day, we do give homage to issues of natural justice. We do give homage to constitutional norms, but only on very limited grounds will you be successful to impugn an arbitral award.
Thank you, Tawanda. It seems that the threshold is very high in Zimbabwe. So what about the United Arab Emirates, Rana?
Before going into the United Arab Emirates, I want to just echo what Wanda had said on, and honestly, I just love the statement of arbitrators have the right to be wrong. It's the first time that I hear it put that way, which is why one of the first things that we really advise our clients is that more important, obviously, yes, choosing your lawyers is very important. Choosing very capable lawyers is really important, but choosing arbitrators who actually understand the legal culture of the jurisdiction which we are talking about, it either makes or breaks your case. So when we say legal culture, it's not only civil versus common law, it's not only the laws, it's not only the court cases, but it also has to do with the legal understanding and the culture itself of the country. For example, if we're talking about the African continent, it's really, it's unmatchable. You cannot compare it to any other jurisdiction in the world. So you need to appoint arbitrators who understand the culture in Africa. So this is perhaps something that really is not really relevant to our topic today, but I'm very passionate about it, so I thought to allude to it. Apologies for going off topic. Going back to the main question, basically, with regards to reasons for set aside of arbitral awards. So I have to say that before the enactment of the arbitration law that was issued in 2018, we saw a lot of really different reasons by which arbitral awards would be set aside or would be sought to set aside. But after the enactment of the arbitration law, we saw the UAE jurisdiction or country and courts as more of, again, pro-arbitration, arbitration friendly, and the courts and the judges really started to understand more what the essence of arbitration is about. So we see less awards that are being set aside because of reasons that were previously relied upon. For example, one of the more let's say, unfortunately infamous reasons to set aside arbitral awards was lack of authority, because arbitration in the UAE is an exceptional mean, of course, to resolving disputes, but as well it's an exceptional authority. So you as the manager do not have the right to arbitrate. Only shareholders or owners of entities have the right to arbitrate. So unfortunately, we saw previously that a power of attorney, again, going back to the power of attorney that I had mentioned before, a power of attorney would be issued from the manager to arbitrate without the manager in the first place having the authority to arbitrate. So unfortunately, that previously just basically caused the award as a whole to fall apart. Luckily, we don't see this a lot these days. We see less and less of them, because again, the courts have more of a positive understanding of arbitration, and also, of course, he who comes to again, I don't remember the exact term. He who comes to court or to law has to come with clean hands. So basically, if you have previously issued the power of attorney and you have seen as the other side the power of attorney being submitted and you didn't really challenge it, you can't come 2 years down the line when the arbitral award is being enforced and say, yeah, they didn't have an authority, or, oh, we didn't have an authority because the manager didn't have an authority. So because of that, now we see the courts really just not relying or really rejecting more these grounds for setting aside arbitral awards. Something else as well that Gerhard has alluded to, which is lack of jurisdiction or invalidity of the agreement. This is, of course, one of the main reasons to set aside the award. But again, the court in general would, if this ground is brought to the court would consider the award itself and would consider whether the party who is now trying to set aside the award because of invalidity of the agreement or lack of arbitral tribunal jurisdiction, they would consider whether that party had previously brought this challenge before the tribunal or not. If they haven't, then the court will most likely ignore it and reject the set-aside request or relief. And again, when it comes to public policy, as Twanda had mentioned, basically any rules that are contradictory, for example, to the Constitution, or that are contradictory to really mandatory rules of the law. For example, if the law, if the UAE law specifically says a company must do X, this is a mandatory rule, and this would most likely fall under public policy. So it would be considered public policy. So a party can rely on it, usually, in attempting to set aside an arbitral award. As I mentioned previously, lack of service. Obviously, the party is not being represented during the proceedings, even if they were served, but if they were not represented, this could be as well relied upon as a reason to set aside the arbitral award. Lack of impartiality of the tribunal, bias of the tribunal. Of course, the threshold is really higher when we're talking about bias or lack of impartiality, because you'll have to really prove why do you think that they were biased. Please give us examples. You can't just claim that they are biased and the court will follow. No, this will not happen. Don't expect this to work here. And of course, we at times see the one-offs basically set aside decisions or reliefs or requests that are based merely on technicalities. For example, that the tribunal has exceeded the time limit to issue the award, although it had the authority initially to issue the award. So the parties would say, no, they didn't have the authority, or they had the authority, but the authority was basically they had to seek our approval each and every time. So again, just to recap this, and moral of the story is that it's not as straightforward nowadays in the UAE to set aside an annul arbitral award. And if you are seeking to do that, you really have to have a very high reasoning or arguments, and the threshold is higher nowadays, which is good.
Thanks, Rana. I think one of the most interesting aspects that you raise is related to timeliness. When did you raise your complaint, whether it is public policy, it is jurisdiction, it's procedural unfairness? Did you raise it before the arbitral tribunal, or did you wait until the award, and then when the enforcement or the setting aside proceedings started, that's when you did raise your objection? And in most jurisdiction, and I'm going to talk also about the jurisdiction where I'm based, Switzerland, you cannot do that. You cannot wait and say choose the moment that you like to raise your objection. If you have an objection, you raise it before the arbitral tribunal. The arbitral tribunal has to decide on it. And then again, if you think that the tribunal wrongly rejected your objection, then you have the opportunity to do it again during the enforcement or the setting aside proceedings, provided, of course, that it fits within the grounds that are provided for in the law governing arbitration proceedings. So I think, yeah, that's a very good point. Charles, I think you are gonna take over from here.
Thank you very much, Panos. I must say that I've enjoyed the discussion so far, but also maybe just to chip in, there are instances where state entities, sometimes they would invoke sovereign immunity as a defense against enforcement. and they would argue that they are immune from the jurisdiction of the foreign courts or foreign tribunals. Sometimes it could be the states themselves or indeed state-owned enterprises. And I have some examples. Like recently, the Paris Court of Appeal refused recognition of an arbitral award under Article 5, sub-Article 2B, using public policy as a basis. And there's also a recent decision from the US involving India, where a lower court decision was partially denied. I mean, the lower court partially denied the enforcement of an award against the government of India. Perhaps maybe I should start with you, Tawanda, since you brought up the issue of public policy as a basis of refusing recognition of and enforcement of an award. How have the courts in your jurisdiction reacted to such circumstances where the state uses immunity or sovereign immunity as a defense? Maybe generally, and then specifically maybe under public policy considerations.
Well, now for us, the recognition and enforcement of arbitral awards is actually the execution of the decision. So from day one, it has to be understood, whether it's a state party or an individual, that the recognition of an award is a precursor to the sheriff or the bailiff in other jurisdiction being empowered to give effect to the award. You immediately have the first problem, which is what we have as a statute, which is the State Liabilities Act. The State Liabilities Act will recognize your court order or arbitral award, but you cannot go and attach a hospital. You cannot go and attach the president's plane. Neither can you attach anything of the state assets. You will have to go to the revenue individuals and the fiscal individuals to then register your arbitral award, and then hope that in the next budget they will make some type of financial accommodation for you. The second question is that public policy in Zimbabwe is a very political consideration. It's a be-all and end-all. It's a bag of tricks that the state has used quite a number of times. We have the very famous distinction of having a court order against us in terms of the land question. But that particular order could not be enforced in Zimbabwe because of public policy. Like I said, our constitution is our guide as to what is public policy, and our constitution was very clear on the land question. Therefore, any arbitral award or any order that goes up against the constitutional norms of the country will not be enforced. What does this mean for our participants today? Our participants need to understand that there are some arbitral awards that are not worth getting and enforcing. When it is against the state, you have to be very clear when you are drawing up your agreements, when you are actually arbitrating, that there is a commitment from the state to then honor the arbitral award at the end of the day. A simple trick that we have had to employ here in Zimbabwe is to basically have performance guarantees or part of the contract that says that there is this money that is ring-fenced or put in trust or put in escrow. And once the arbitral award is presented to a particular individual, whether it's the state or whatever the case may be, that escrow agent will release the money. So the short answer is that public policy tends to become very political, and you need to be very aware of the politics when you're going up against the state. Certainly, I do not think there's any country that would allow an ambulance to be attached on its way to the hospital.
Thank you very much, Tawanda. I think that's a shot fired for everyone. If they are drafting arbitral clauses, to be mindful of what Tawanda said if you are proceeding against a state or any state-owned enterprises in Zimbabwe. Gerard, what's the position in South Africa in terms of sovereign immunity and how the courts have reacted to that?
So sovereign immunity is seldom in itself an issue in arbitration, because under South African law we distinguish between sovereign claims premised on sovereign acts of state versus the transactional and commercial activities of a sovereign. So if a sovereign contracts for the rendering of and by the way, sovereign immunity doesn't relate to state-owned entities in a South African context, but even sovereigns outside South Africa, where there's a party comes to seek recognition and enforcement for purposes of attempting to attach the assets of or register an arbitration award against a non-South African entity with a view to attaching assets in this jurisdiction. To the extent that a sovereign engages in commercial activity, such as the conclusion of a loan agreement or contracting with a party to undertake certain works or performance that's treated as commercial activity, and sovereign immunity would not be considered to apply to those transactions. So sovereign immunity is not what one would typically find is the subject of challenge on recognition and enforcement of an arbitral award in SA. Far more likely is a challenge to the capacity, the fundamental validity or the authority of the party who concluded the arbitration agreement in the first instance, where the suggestion may be, and this particularly where you deal with, say, an arbitration award granted by default, where the defense would be raised to challenge the capacity of the party who purported to subject the particular sovereign to the agreement to arbitrate, and with the suggestion there being that there was no conduct on the part of the sovereign to participate in the arbitration, and there was fundamentally no authority by the party who purported to contract to give the arbitrator the necessary authority ultimately to deliver an award, and that sort of challenge I've certainly seen. In fact, there's some live proceedings at the moment where this is very much the defense which is being raised on the part of an African sovereign in litigation before the South African courts. But this is not what this. I mean, this goes to capacity and authority and whether or not there's a valid agreement to arbitrate. It doesn't fall within the area either of a debate around sovereign immunity or the question of public policy. I hope that helps.
Very much. Yes, that's quite helpful, and we have learned quite a lot from your experience, especially in terms of what you have just said, that there's a pending dispute where that is being put as a defense. I hope maybe when that dispute is concluded, perhaps maybe you'll be able to share some insights that will come from that.
I would be happy to.
Thank you. Rana, what's the position in UAE?
So I'm going to talk from a UAE perspective about the enforcement process, immunity when it comes to enforcement. Because just as Gerhard mentioned, when it comes to signing the arbitration agreement, you just need, as a party entering into an agreement with a state entity or with the state, to just confirm, review the documents to confirm or to verify that the signatory actually has the authority to sign on behalf of the state or the state entity. So I'm not going to touch upon that. I'm going to touch upon the immunity when it comes to enforcing arbitral awards. So this actually will apply to both judgments and arbitral awards. So when it comes to attaching assets of the state or state entities, this is not allowed, i.e. attaching for the purposes of enforcement or attaching as a provision measure. because the civil procedure law specifically states that public property owned by the state or any of its emirates may not be attached. So if you have an award that, or a judgment, but here we're talking about arbitral awards, if you have an award that is being enforced against the UAE entity or one of the UAE state or any of the emirates or any of their entities, the first thing, to be honest, that is advisable is to seek settlement, to try to settle this amicably. If you manage to do that, perfect. If you don't manage to do that, then try to get it enforced somewhere else in another jurisdiction, because attempting to enforce it in the UAE, it will be an uphill battle, because the law specifically says that, again, state properties cannot be attached. But okay, so there is some distinction, or there is some unclarity when it comes to state entities, i.e. entities that are owned by specific emirates or by the UAE as a whole. There was actually a judgment between Middle East Foundations LLC versus Midan LLC. Midan LLC is an entity that's owned by Dubai, if I'm not mistaken. And from that judgment, it appeared that basically companies owned by the government are not intended to fall within the scope of the protected governmental entities or protected governmental assets, rather. But again, as I mentioned earlier, there is still some unclarity when it comes to that. But when we talk, I mentioned civil procedure law in general, which applies federally, i.e. all the UAE, all the Emirates, all the cities, etc. But there is also there is also a law specifically for Dubai, which says no debt or financial obligation against the ruler or the government may be collected by means of detainment, public auction, sale, or possession by any other legal procedure or of the properties and assets of the ruler or of the government, i.e. Dubai government here, whether such debt or financial obligation has received a final and conclusive judgment or not. So as you will see, everyone, the law is really clear, whether the federal law or the Dubai specific law, that properties that are owned by the states you will not be able to attach or enforce against. So again, it's on a case-by-case basis, but seek settlement. If you're not able to settle, then try to enforce it in another jurisdiction. I think that would be much easier.
Thank you very much, Rana. That was quite insightful. How about my neighbor, Zambia? What do I need to know if I'm representing a party that basically is proceeding against the state and we're about to enforce an award against the state of Zambia or state-owned enterprise in Zambia? And perhaps maybe also to check if at all there's any jurisprudence from the court on that issue.
Hi, was it my turn?
Yes, and
oh, sorry, I lost my connectivity for a minute there. So for Zambia, on sovereign immunity, the courts they respect the immunity of states as well as their instrumentalities, and these are protected from being subjected to certain legal processes. However, there are instances when this immunity will be waived. And one important consideration that has also come out from the other speakers is if the state entity was clearly taking part in a commercial transaction, the courts have overlooked this immunity in such instances where the intention was clear that the state party was intending to be bound by these transactions. And also they'll look at the arbitral clause as well, the arbitration clause, to see the intention of the parties. Is it very clear that the state party intended to subject itself to the jurisdiction of arbitration? If it's clear, then this intention will be upheld by the courts. And also there's the issue of the state parties, Zambia being a party to a treaty with a particular state party. If there are treaties in place, then the courts might have to uphold these treaties and not waive immunity in that instance. So that is how Zambia has approached the sovereign immunity question. Thank you.
Thank you very much. I think I would echo what Rana said at some point to say, I think it's important that we need to understand each particular jurisdiction in terms of the laws that are prevailing when it comes to enforcement. I think it's a very important aspect as arbitration practitioners before we start advising our clients. Otherwise, we may end up taking up instructions where it will be sort of a futile exercise. All right. My next question relates to staying over execution when it comes to the enforcement processes. Have we had situations where maybe courts have granted an order for stay over execution? I just want to understand the approaches within your jurisdictions. So perhaps this time around, I should start with you, Gerard. If at all in South Africa you have had situations where you are in the course of enforcing an arbitral award, and then you get to have an order staying that process of enforcement.
And indeed, yes. So most typically that would happen again with international awards rather than domestic, because with domestic there's usually the parallel challenge by way of a review or otherwise, which would already inherently place before a South African court an active decision whether or not on the merits the award should be enforced or not. But where you have an international award, there would typically be some level of challenge that would be taking place in another jurisdiction. But pending the outcome of that challenge, there's a valid and binding award before a South African court that it's being asked to enforce.
That's it.
So in those circumstances, it is in essence an application for an interim stay on the enforcement of an award if there cannot be an agreement between the parties. And in those circumstances, the base premise that the court would apply in its discretion would be quite similar to that of an interim injunction or interdict. So the court would evaluate at least what the prima facie merits are of the on the prospects of the challenge, and ultimately also consider whether there's any prospect of irreparable harm that might be suffered in the event that the award was enforced on an interim basis. The arguments that would follow then would be whether or not some level of security should be set, whether or not there's some anti-dissipatory issues that also need to be considered on the part of the interests of the party seeking to enforce the award, and where ultimately the balance of convenience lies, as well as the notion of irreparable harm.
Thank you very much. I remember, Rana, you mentioned that in UAE, it's quite an uphill task to challenge enforcement of an award. Maybe just to learn from your jurisdiction, have you had such situations where courts have granted an order for stay of the enforcement process?
So similar to challenging arbitral awards as well, staying an arbitral award, it's not a straightforward process. It is definitely possible by law. It is stipulated in the law that the parties can apply for this, but you need to basically provide sufficient arguments or evidence that why this is necessary and that you are actually going to be harmed if execution proceeds. For example, let's assume
Yes, somebody put a stay of execution on Rana's internet connection.
Yeah, I think
if
we have
that's
lost. Okay,
Hello.
Rana,
Hi.
we temporarily lost you.
Oh, sorry. What was the last thing that you caught?
Basically, you're trying to give an example. So,
Oh, yes.
yeah, sure.
So, for example, if the seat is not in the UAE and the winning party decided to come to the UAE for the purposes of recognizing and enforcing the award, so then what you did is that you tried or attempted to set aside another award in the seat of the arbitration agreement itself. What you could do is that after you file the set aside proceedings in the seat, you could basically submit an application here in the UAE saying, okay, so there are reasonable arguments for setting aside the award, and I have sought the set aside in the appropriate jurisdiction, and basically continuing with the enforcement is going to harm me or going to impact my assets or going to cause this and this and this basically effects on me. So again, just moral of the story, you have to really have some strong arguments on why the stay of enforcement will need to be granted to you.
Thank you very much. Annie, in Zambia, do we have anything in terms of the staying of execution of enforcement of an award? Something that we can learn from? You're on mute?
Okay, so I was saying that in Zambia, the courts have held that the fact that an award is enforceable in the same manner as an order of the court does not in and of itself render it open to a stay of execution. The feeling by the Zambian courts is that they cannot stay that which they did not render. And so it's not easy to get a stay. It hasn't been done. However, interestingly, from my experience, opposing counsel would proceed to put in a challenge to the enforcement of an award, knowing that the other party can't proceed to get an order of enforcement because no court would want to give an order of enforcement when there's a challenge to the award. So my experience is that even if the courts will not give a stay, the fact that there's a challenge in place makes it impossible to execute, so it ends up acting as a stay. So that's the Zambian position.
Thank you very much. How about our friends in Zimbabwe? What's the position out there?
Once our courts have recognized an arbitral award, and the sheriff, or what you call the bailiff in some jurisdictions, has been given the go-ahead to execute, it's too late. It's very difficult to get a stay of execution against the enforcement of an arbitral award or a court order for that effect. We have a joke that once you see the sheriff, it's too late, leave it alone and comply. But there is a very important case that was done some years back in 2006, whose quotation might help you understand why we have taken that view. This is a judge who stated that the Arbitration Act is of international pedigree, and certainty and finality of legal proceedings are paramount to its formulation. And because of that, because of the fact that we believe that arbitral awards should be final and they end litigation, filing an application for stay of execution can easily be seen as adventurism and might end up causing more problems for your client if you are the one who's seeking a stay, because once the dispute is ended. Once there is finality, they do not want to use the stay of execution process as a manner on which to forestall what has been ordered by an arbitral award. At the end of the day, I would say that, yes, people have tried it. Yes, people sometimes have caused delays, but eventually, once that arbitral award is recognized, it will be enforced.
Thank you very much, Tawanda. Lastly, I'll ask basically two questions. There's a lot that has been shared this evening, and I'm sure our audience have also learned quite a lot. So basically, as experts, what practical tips would you share with our audience in terms of the enforcement of domestic and as well as foreign awards? And as we are answering that question, also look at which skills should junior practitioners focus on and develop to tackle the enforcement of arbitral awards. Perhaps maybe I should be as open as possible. Anyone who would want to start sharing their insights on these two questions?
Can I go first?
All right. Yes, go ahead, Rana.
So on the first question with regards to the practical tips, it's also another saying that I am using from a dear friend of mine that I've heard recently. Cheap lawyers are really expensive. So make sure to retain good lawyers who know the law, who know the culture, who know the legal, who have the legal knowledge, really, because unfortunately, clients decide to go with lawyers who basically think that they're not going to cost them a lot because they quote them very less. But unfortunately, those lawyers eventually will have to either amend their cost and basically quote what it will actually cost to enforce the award, or the same individuals or clients will have to retain other lawyers who actually know what they're doing. So cheap lawyers are expensive. And also just another tip is also just be aware of the documents that you have to provide, that you have to present. Don't try to cut corners. Don't try to basically follow any shortcuts, because this is just a procedural process. This is just a process that has to be followed. So if the law says we need ABC documents, then we actually need ABC documents. If the law says we need translation, we need translation. We need power of attorney, we need power of attorney. So there is no basically reason to try to be extra smart and cut corners here, because usually when it comes to specific sets process, it will not work. So just understand the process when you are doing this. My basically advice perhaps for junior practitioners is, just like anything else when it comes to enforcement of awards, do a lot of listening. Just listen to what everyone is saying basically, and maybe just be very attentive to what your senior members or senior colleagues are saying and discussing when it comes to enforcement. Attend events, these like actual in-person events, to understand more about the actual the actual practice of the courts, because the law could say something and then the courts say something entirely different. So do a lot of listening, do a lot of attending of events, but as well, you need to be reading. You need to start reading ASAP. You need to start reading judgments. You need to start reading awards if you have access to those. You need to understand how this practice works as early as possible. I started 6 years ago and I was really lost, and I'm honestly still learning each and every single day something new when it comes to arbitration, when it comes to enforcement. So this is my advice to all the junior practitioners. Keep listening and keep reading. Thank you very much.
Thank you. The highlight being cheap lawyers are expensive. Annie, you seem like you want to say something as well.
Yes, in keeping
Yes.
with ladies first, I thought I should go next. And also on a light note, cheap lawyers are expensive, so go with the experts on this panel. Anyway, so in terms of advice, I recently was speaking at the Africa Bar Association on this subject of the courts across Africa needing to reinvent themselves to make themselves suitable to handle arbitration, challenges to arbitration awards. The truth is, challenges to awards will be there. But if our courts are not well structured and well capable to handle them, then we see these delays, and the delays themselves end up being an injustice. So I would say to this, to the listeners, to this panel, to say, let's go out there and lobby and advocate for streamlined court processes, to have judges who are well-versed and able to handle arbitration questions when these awards are raised, so that the challenges to awards can be dealt with speedily, in line and in keeping with the whole concept of arbitration is faster. You know, how can it be faster if challenges are taking over 2 years, over 3 years? So that's what I would say. We want arbitration to be the go-to forum, and that can only happen if we see good results coming from it. We see that justice is being dispensed speedily, even through arbitration awards. With that said, for the skills which I think young lawyers and would benefit from, I would say negotiation skills, honing in on those negotiation skills so that there is no need to have to enforce their word anyway. Once you get their word, if you can get talking with the other party and get to an amicable agreement and timelines, then there's no need to start involving the court process. So just getting knowledgeable about negotiation and just refining those negotiation skills is a piece of advice I'd give. Thanks.
Thank you very much, Anna. And to what you have said, I dare add that I think it's also important for everyone to also have the skills in the practice of arbitration, because sometimes some of the problems that are faced because some of the representatives on the other side maybe don't understand some of these processes and how they work. So I think it's important that we get the necessary skills in this area and we properly advise our clients. Gerard, what do you have to say?
I think as a corollary to what was said earlier, somebody once said, if you think it's expensive to hire a professional, try hire an amateur. But more seriously, there are two quite distinct areas here that I think one needs to focus on. One, the one are the fundamental principles of arbitration and ensuring that arbitration and arbitration process is properly followed through to ensure that you have a valid and enforceable award, and being able to understand and appreciate what that means in the context of the broader principles of international arbitration and also the intertrial model law as generally recognized and applied through the New York Convention. That's the one element. Quite separate from that is a thorough understanding and appreciation of the relevant civil procedure and jurisdictional requisites within the jurisdiction that you are trying to have that award recognized and enforced. And that may be your home jurisdiction where you are sufficiently comfortable with the applicable principles and the relevant pitfalls that might come to the fore within your jurisdiction. But these are two different skill sets, and they do reflect on different levels of direct experience. If you are going to seek to enforce an international arbitration award in a jurisdiction other than your own, make sure that you are engaging with somebody who has the appropriate level of experience and and in terms of recognition and enforcement within that jurisdiction, because the practical realities in my experience of trying to enforce arbitration awards in jurisdictions which at face value seem to be quite similar to your own, in recognizing the New York Convention, having legislation which corresponds with the UNCITRAL model law, can be quite different when you find yourself before a local judge seeking to enforce an award and finding that the reception you get as a acting on behalf of a foreign client within that jurisdiction can make it practically very difficult to achieve what seemed to have been quite a simple result. So beyond the notion of cheap or expensive lawyers, make sure that you have someone who has demonstrable experience within that jurisdiction and appreciate and recognize that enforcement in civil law is quite different from being a successful arbitration practitioner.
Thank you very much, Jared, for those insights. And I should also add that I also am involved in some dispute from another jurisdiction. I have some expertise in arbitration, but because we are dealing with a specific jurisdiction, I had to engage someone who has the experience from that particular jurisdiction. So yeah, that's quite helpful. It does simplify the work for you. It's important that sometimes we embrace that. Tawanda, anything to add on what others have already said?
Yes, I think the most important thing that I can tell everybody today is that don't make the mistakes I made. Years ago, when I was much younger and I had more hair, I thought arbitration, if its process and the enforcement is informal. Generally, that's how it's taught in most law schools, whether it is in Africa or in Europe. There's this misconception that arbitration is somewhat informal, more relaxed than litigation. It's not. It's not. It has very clear rules, very specific issues that need for you to learn. You need to give yourself time, and you also need to be humble enough to understand the process. The worst thing that can happen to you is to have a $19 million matter. You think you can enforce it in Mauritius. You get onto a plane, you make the client pay plus the holiday. You get there and you realize that everything is in French. It's extremely important for me to reiterate. Do not think that what we are dealing with is informal. Do not think that you can navigate your way without acquiring knowledge. And more importantly, the practitioner next door who has done the thing that you want to do is your most important ally. You might have to humble yourself and simply ask the question, but why is this being done? That's the question that I never used to ask in my youth, and I paid for it dearly in losing clients, losing cases, and more importantly, losing the trust of colleagues. It's extremely important to try as much as possible to ask the question before doing something.
That's quite powerful, Tawanda. I see, Rana, you seem like you want to add something to the conversation or discussion. Maybe if you can just be as brief as possible.
So it's just basically what Tawanda had mentioned about Mauritius reminded me to also say that please consider retaining or hiring asset tracers if you are considering enforcement, whether in your own jurisdiction or elsewhere. Asset tracers could actually just cut off a lot of the time that you might lose in trying to enforce an award that is unenforceable simply because there are no assets to recover from. So yeah, that's the only thing that I wanted to add.
Thank you very much, the speakers. It's been quite an insightful discussion, and I'm sure maybe our attendees have some questions. So I'll ask my colleague Panos to take us through the next session, which is the Q&A session. If at all, maybe we have some questions from the audience.
Yes, happy to do that. Thank you, Charles. I'm aware, of course, that we're getting close to the 2-hour mark, so I don't want to drag this for too long. But perhaps we could get to a couple of questions that the audience has asked, and one of them is a point that we haven't touched upon yet, and it relates to pathological arbitration agreements. And the question is, how do your respective national courts deal with such clauses? Perhaps, again, I don't know if Tawanda wants to start first.
I think I'll answer it in a different way. In our jurisdiction, we have a pro-contractant view. Whatever you put in your agreement is what the courts will enforce. So regardless of the type of clause that you put in, or the type of process that you infuse into your agreement, in fact, there are 3 types of agreements that will be enforced in an arbitration. First of all, the primary agreement itself. Second of all, the procedure that you agree to. But more importantly, we are a pro-contract jurisdiction, and you can put anything there as long as it is unlawful. So your quick answer is whatever you put in your agreement, as long as it is lawful, it will be enforced as is.
Yeah, just to comment on what you've said, in many jurisdictions, I think courts will look for the basic, let's say, element of an arbitration agreement, which is the will of the parties to arbitrate. And everything else, in theory, again, can be interpreted and applied in a certain way that will favor arbitration. But the court will first look, like the first thing that they will look at is whether the parties consented to arbitrate their disputes. But again, that's how I understand is the position here in Switzerland. Perhaps, yeah, in other jurisdictions, the approach of the courts is different. So perhaps, Rana, you want to go second?
So when it comes to pathological clauses or agreements, it really, and again, that's assuming that an award has already been issued, right? This is what we're assuming, that we have an award that we're trying to enforce, and maybe one of the parties or the losing party is claiming that the agreement itself is invalid. So again, I'm assuming that. So as long as the award and the tribunal basically had deciphered, let's say, the pathological agreement or clause itself in a way that is very that is convincing to the reader of the award itself, so the tribunal has the jurisdiction to do that. The tribunal has that competence basically to do that. As long as the award is very detailed when it comes to that clause, I don't see how the court would intervene or interfere in trying to re-decipher, for example, or reinterpret this agreement. So it goes back again to the constitution of the agreement and to choosing a tribunal, the constitution of the tribunal, and to choosing a tribunal that actually knows what it's doing, going back to experience and legal culture, etc., etc.
Thank you, Rana. Annie, would you like to share your perspective from practicing in Zambia?
Yes, so in Zambia, a pathological arbitration clause would render the arbitration proceedings ineffective. In the case of Flodak versus Wangwa Roses, this was precisely what the case was, the courts were dealing with. There was a clause in which it was stated that a dispute would be subjected to both arbitration and litigation. So the clause was held to be pathological and the arbitration proceedings could not proceed. However, if the courts show an intention to proceed with arbitration, then they can agree to draft a new clause, and the arbitration proceedings would then proceed on the basis of the new clause.
Thanks, Annie. Gerhard, any views?
Again, it would depend very much on what the notional defect is in terms of the clause. I think the South African courts too, in interpretation, would do their utmost to give effect to the party's intention, and if there is a clear intention to submit to arbitration or some form of alternative dispute resolution that was enforceable, then the courts would support that. If the defect is, for instance, the lack of provisioning for the nomination of an arbitrator, then the courts would facilitate that. If the defect is, as the example was mentioned, let's say a level of a lack of clarity as to whether or not the parties intended to submit to arbitration or to the jurisdiction of the courts for purposes of dispute resolution, then there again the courts would probably err on the side of interpreting the intent in the parties to a route that would have maximum efficacy. And if the parties by their own conduct then elect to submit to arbitration, then that the court would probably also take the approach that a subsequent submission to arbitration by conduct and participation in the arbitration process would give support to an agreement and consent to submission to arbitration in its own right. So this is an area of dispute which, again, in the absence of a default arbitration award, is unlikely to be the subject of a hearing challenge. More likely as not, where one of the parties is seeking to pursue some level of declaratory relief from a court or from an arbitral tribunal at the outset of the proceedings. And most of the time, if the type of clause that we're talking about is one which seemingly gives the parties an election as to which forum they choose for resolving their disputes, as opposed to a anticipatory submission to a particular form of dispute resolution, then again the conduct of the parties is likely ultimately to be given effect to by the courts.
Thank you. Thank you very much for this insightful reaction. Thank you.
I'm very jealous of all the other people there who have got very intelligent answers there. I just wanted to say to you, in Zimbabwe, even if you misspell arbitration and say it in an agreement and the judge sees it, that there is a possibility or a whiff of alternative dispute resolution, it is likely that that will be enforced. That was what informed my answer, that as long as the parties want to arbitrate, have indicated, even sign language to say that this might be arbitrated, and the parties are in agreement that it must be arbitrated, I have not really seen any real problems on those type of clauses allowing a party to escape the possibility of arbitration.
Maybe I can just come in. I would just want to add to what you've just said, that perhaps Zimbabwe seems like the model for arbitration. Like, it seems like the place where we all need to be practicing arbitration in Africa. Yeah.
Unless the counterparty is the state.
Yes.
or the award is in Greek. But yeah, that brings me to the final question, actually. Anya, you raised a good point, and I just wanted to it's an interesting question, I think, but I don't know if you have the answer to that, is whether you have seen any correlation between the number of setting aside applications or enforcement applications and the popularity of an arbitral seat. So if you see more and more, let's say, setting aside proceedings, do you see the popularity of that arbitral seat to go down? Have you experienced anything like that? Have you advised any of your clients with respect to that issue? Perhaps I'll ask Annie to go first.
Yes, thank you for that question. That's a question that's close to my heart. I'm actually involved in a legal dispute that started out with arbitration, and I think we're like in our third year, headed to the Supreme Court now. It's left a very bitter taste in my mouth, obviously, about my country as the seat of arbitration. Not to put Zambia in a bad light, I think the courts have in other instances really done well with arbitration proceedings, and we are really pro arbitration, except for certain instances, as in my case where the case drags on. But I'm passionate about this issue because I feel like unless we refine our court processes and the country changes its approach towards arbitration, it will not be popular as a seat for arbitration. And that filters through to businesses and commercial transactions and your ability to retain investment in a country. So it's paramount that countries take a united approach, an international approach in the way they handle arbitration proceedings so that they're dispensed with more quickly, because there is that correlation. And we are putting ourselves out of the market when we drag on cases and don't deal with them effectively and in time. Yeah.
Thank you, Annie. Anyone wants to go next?
All right, I'll go next. The truth of the matter is that arbitration in Zimbabwe has become popular for three fundamental reasons. The first one is that litigants lost faith in the speed of conventional courts in Zimbabwe. We used to have this joke that once you file a notice of appeal in a commercial dispute, the likelihood of a change of government in Zimbabwe will be much more than you getting an early set down. And we've only changed government once. So the truth of the matter is that the speed of arbitration is one of the attractive things that we as practitioners should encourage our clients. And it would work in any jurisdiction to highlight the ability to have your own timelines. You can have time-sensitive arbitration that allows people to resolve their disputes faster. The second reason why arbitration became a little popular in Zimbabwe is the ability to choose your own adjudicator. And that is coming from the need. Sometimes the matter is so important, you are worried that a member of the judiciary might be corrupt, biased, or whatever. And that's something that is a bit common in African countries. So it's for us who practice in those type of jurisdictions where litigants have lost faith in the courts, it is important for us to encourage our clients and say, look, we can choose our own adjudicator. It's extremely important to do that. And the last reason is that expertise. It's not every single jurisdiction that is fortunate to have judges who are experts in construction law, who are experts in mining law, who are experts in some of these things. So I have an arbitration that we are simply fighting about the value of shares and putting that before my normal judges who are used to people fighting and biting each other up over custody. It becomes a little difficult. You would have to, the case becomes longer because the judge is learning as it goes. So the third reason why arbitration has become a little popular in Zimbabwe is primarily the ability to have experts who might not necessarily be lawyers, but who come and say that this is how a radiography equipment should be used, and the contract was not properly, also the radiography equipment was not properly fit into a hospital. So the ability to choose experts. So those are the three reasons which I believe that if all the participants go back to their constituencies, go back to their clients and say, these are the three things that have worked in Zimbabwe. If anything can work in Zimbabwe, I think it can work anyway.
Thanks, Tawanda. Rana, any final comments? Sorry, I didn't hear well. Sorry.
Could you remind me of the question?
Yes, well, the question was whether you have seen any correlation between the number of setting aside attempts, applications, and the popularity of the United Arab Emirates as an arbitral seat.
So yes, definitely. So the popularity of the UAE and in general and Dubai specifically as a seat of arbitration has really started, let's say, growing and increasing since the arbitration law was enacted. When the arbitration law was enacted back in 2018, it first of all, one of the main changes that it introduced was that it cut down the time for info, and also the arbitration law was enacted and also the civil procedure law was amended. When those two things happened, they cut down the process for recognizing and enforcing awards and also setting aside awards from literal 5 years, i.e. as long as normal substantive proceedings, to a few months at times. So this is huge. This is significant. We don't see this in a lot of jurisdictions. Most of the jurisdictions that I deal with, most of the jurisdictions that I hear about, to be honest, the process of recognizing and enforcing and setting aside award can take up to, I don't know, a few years at times. So, which is obviously unacceptable. And also, in addition to that, because of the UAE being really a business hub, I would say, in this region, the government of the UAE itself, they are educating the judiciary, they are educating the practitioners themselves. They want more educated people to take care of this practice here in the UAE, so that basically more arbitrations are seated in the UAE. And this actually started changing. For example, as the last statistics that I heard about a few months ago was that Dubai as an arbitration seat is now the 8th popular in the entire world, literally, as an when it comes to ICC proceedings or ICC arbitration cases, which is, this is really unmatchable, I think, in my experience. Also, another reason for the UAE becoming basically a well-known seat for arbitration is because arbitration now in the UAE is, we can see more and more that it's becoming the preferred method of resolving disputes, even for UAE parties. Even for UAE parties, parties tend to go, whether they're small enterprises, medium enterprises, they started believing more in arbitration and understanding that arbitration actually is, we can say at times, is the right way to go, basically, because of all the reasons that Twanda had listed, because of the expertise, because of the, because basically of the confidentiality. There is a lot of reasons that I don't think that basically 2 minutes will really be enough for me to list them. But yeah, the answer is the UAE is becoming a popular seat for arbitration, and arbitration is becoming very popular in this jurisdiction.
Thank you, Rana. Thank you. I think in the interest of time, we're going to conclude here. All that remains for me is to thank our speakers for their insightful contributions and useful tips on how to tackle enforcement issues in their respective jurisdictions. I have personally learned a lot from today's webinar, and I hope it's the case for our participants as well. So thank you very much again, and thank you also to our participants for joining us today. And as I said at the very beginning, the webinar is recorded, and you will be able to consult the recording of today's webinar on AFSA's website. So thank you very much again, and I wish you all a very nice evening. Take care.
Thank you so much. Thank you
Very much. Have a lovely evening. Thank you.
Thank you. Bye-bye.